Okay, so we are at the bottom of Samach Hey Omid Beis, and this is coming to a new topic, but continuation of the very detailed discussion about how ribis, and again, ribis d'Rabbanan, we're not talking ribis d'Oraisa anymore. Ribis d'Rabbanan can occur in all kinds of circumstances that we may not even be thinking about. All of a sudden, you're in a ribis situation, as we've served before, and as this Gemara today is going to show us, that rivers can creep up on you without your even being aware. So we're going to start this. We're going to have to refer back to something we did last week, but I don't want to go back into it now. So we're going to start with the Gemara, who gavra de zovale ara lechavre, shelo be'achrayus.
So,
So
Rabbi, can I ask a question first? Is
yes,
there such a thing as ribis shogeg as a topic? Somebody didn't know that,
the Gemara later may address it, but when you say ribis shogeg, you mean that they're doing something without even realizing it's
right?
ribis.
Or
But
it,
that's
it's or it slips in without even realizing it.
But yeah, but Jay, all of the discussions that we're having are pretty much bishogeg. I mean, two people interact, they do something, and
And
bingo, all of a sudden it's ribis. They didn't intend for it to be ribis. They intended on a regular transaction without any even idea or intention that there would be ribis, and then ribis jumps up at them. So I think the term shogeg, I'm not sure that there is a more formal discussion later in the Gemara. We'll see. But I think you can count on the fact, as you're going to see again today, that it happens b'shogeg. It isn't an intentional thing. They contract to do something, and before you know it, ribis is there. I mean,
yeah,
they didn't intend for that to happen. So I think that that's how you have to look at it, is that these are all shogegs. These are all accidental, non-intentional ribis events. And that's why the Gemara goes into all of them to show you how easily sometimes rivers can jump at you. Um, you have to be well versed. You have to be
well,
well versed, which is why I think the intention is that when two people interact, they should consult in advance. We're having a transaction. Is there a question of ribis? I mean,
But
sometimes,
Rabbi, when we started out, it was intentional because
yes,
it
yes,
was a
absolutely,
matter of, okay, I want a deal. You want this, I'm going to charge you extra to be able to do that.
correct.
That was
Yeah,
all intentional.
right,
And I
totally.
think Jay's, I don't want to speak for Jay, but I think his question is the Gemara doesn't seem to differentiate between intentional and unintentional, where it's deliberate. And
That's correct. That's correct.
so,
But ribis Rabbanon, remember, not ribis deraisa, ribis Rabbanon, whether you intentionally have in mind, which is not so easy, by the way, with ribis Rabbanon, but let's just say you have intentionally in mind to be able to get ribis, is no different than making a deal without ribis even being on the table, and then before you know it, there's ribis. So you are right, Michael, that
and the punishment is no different whether it's intentional or unintentional as it relates to ribs.
correct.
So that's how severe the violation is. I would
That's
guess
correct.
that it
Right.
doesn't differentiate
It
them.
doesn't
I
differentiate.
would have thought that the Gemara would have a whole discussion calling it ribis shogeg as a category
Yeah.
to make it clearer to all of the students like us that it's just like Michael said, when it's intentional, the Risa was one thing. When you switch to the Rabbanon, there are two categories.
Right. But remember that we now know, I mean, we've known for some time that one can do tshuva for ribis. So yes, it's a very harsh thing, and for which if you don't recant or you don't make good, there is even midrabanan. There's it's not going to be a necessarily a monetary penalty, but of course, b'dei shemayim, ribis is always considered to be a serious violation. But the fact of the matter is that you can recant. So if two people get into a situation where, oh my gosh, we have ribis here, we didn't realize that. The good news is it can be undone. So it isn't, yes, it's severe, but the severity is tempered by the fact that we can undo it and make it right. And I think, as far as the title Shogeg J, I don't think that the Gemara operates that way. It doesn't just say, okay, these are bemazed, and now we're going to do b'shogeg. I don't know that that's exactly the way it'll be. We'll see. Maybe the Gemara later on has some discussion. I haven't previewed it, but let's take a look. So let's take a look at an example here. This is a very interesting discussion. We know that certainly in our law and in our time, there is such a thing as a warranty. A warranty is something that is given, say, by a seller to a buyer, that I'm going to sell you this, but I'm going to give you a warranty against. Okay, in this Gemara, we're talking about someone who comes in and has a claim on my property, and therefore, because I sold it to you, the long arm of the law will allow him to go after the property even to the buyer. So the seller gives a warranty. If that should happen, I will replace it. So that's the kind of warranty that we're talking about. Now, I don't want to get too deep into it, but in our law, we have something called express warranties, implied warranties, meaning that even if you don't express it in so many words, there is an implied warranty. We'll look at that a little bit later, but nevertheless, the term achrayus is a warranty. So who gavra dezavale ara lechavre shelo biachrayus. In the shtar mechira, there was no warranty. He did not warrant the property. Okay, now chazie dehavako otziv. So the seller saw that the buyer was upset. Why was he upset? Because there was no warranty. In other words, the seller prepared the contract, gave it to the buyer. The buyer looks at it and says, "What's going on?" Omale, so the seller, the meicher says to the buyer, Am I yetzivet? Why are you upset? So then he speaks out. He says this: "Itorfulo minach." If I have a creditor, let's say, someone who has a taina to me, and he comes and takes the property from you, because in that chain he would have kedima, because the let's say the loan or whatever it was preceded the sale, so you can't get out of the loan by selling it. That's not allowed. So he says to him, if the creditor comes, magbilach shufra, then I'm going to compensate you and I'm going to give you a property. Not only that, shvacha operi, plus if shevach, if it increases in price, or the loss of the fruit, the produce, I'm going to make all that up to you. It's all going to be good. All right. So l'chayra, it's not in the shtar, but he is voicing that to the buyer. Don't worry, I will take care of it. So the question becomes: is that a valid warranty? Is that a valid warranty if you don't have it in writing? Omar Meimar, so comes on Meimar, and he says in such a situation, Petume mila ba'almahu. It's not achrayus. It is not a warranty. It's just Petume milsa. He's just giving him some comfort. In other words, he wants to assuage his concern that something might happen. So he says, don't worry about it. I'll take care of it. So when you think about it, the first question that should come to mind, and we're going to see how the Gemara deals with that, is why doesn't the lokeach, the buyer, say to the mocher, put it in the contract? Just write it in that I'm giving you a warranty. Why is it left out? And the mocher is sort of giving him comfort by saying, "Don't worry, I will take care of it." So a member says it's not a promise. It's not absolutely I will take care of you. It's more just to assuage his, because he saw that he was upset. So he said to him, "Don't worry, I'll take care of you." Okay. Word to the wise, don't accept, when you're dealing in a contract, make sure it's in, as we like to say, the four corners of the contract, and there should be no ambiguity that you're making this condition, because otherwise it could be a serious situation where he's going to lose the property. He'll lose the property. So, in any event, so this ruling of Almeimer is now very important. That he comes and says that it's not a solid yes. It's I'll take care of it. Okay. So now, so that's where we are, and that's an important jumping point to what we're going to learn.
So, excuse me, Rabbi.
Yeah.
So when you have industries like the diamond industry,
Right.
and they do things without written contracts, and it's a handshake or whatever the protocol they use, how does that fit into? Is that considered a warranty in Manhattan
So
when
that's a
people shake on a diamond?
so it's very interesting because in the Jewish world,
Right.
um, and I don't know if there's actually cases before Besdin, but I certainly know from hearsay that in the Jewish world, a handshake is a contract, and you have to stick by that, because if you violate that, then you're ostracized forever. So there is a certain sort of understanding that among the parties that they will transact fairly, and if it turns out that he gave him a diamond that wasn't so I, and he paid for something better, then he has to make good. So, but that's in another world. In a court of law, that's not a contract. But they don't go to courts of law; they go to Besdin. But in a court of law, a handshake is not really a contract. Now, in some states, I think Florida being one of them, an oral agreement is contractual. If two people enter into an oral agreement without writing, and it can be proven, I mean, ADM or whatever, that's a contract. Not every state, most states don't. Most states says the contract, you have to do it, the right way. But certainly in a Besdin, that would certainly hold water if the parties made a deal, handshake or whatever, made a deal, then it would be as if they had written a contract. But you have to be careful there, because if you wanted to take this outside of the Besdin, you have a real problem. Okay,
Right.
so that's where we are. Now the Gemara says, "Amalei Rav Ashi l'Rav Meimar." So Rav Ashi is now going to sort of ply or peel away the skins of what is a Meimar really saying? Why did he say it, and what's he saying? Tamamai. Why is this promise, this consideration, not considered hard and fast? It's not a binding like an achrayas. Why is it not? I mean, he said to him that he'll make do. Why is it not? So listen to what the answer is. Kiven de lokeach bolas nue, which I just said before. Why didn't the buyer come to the seller and says, put it in writing? So in other words, the chrayas is now on the buyer. He should know better.
To
He should,
protect himself. Yeah.
yeah, he hurts himself. Why would he not say, I'd like it in the contract, just put it in? So, um, so in other words, he's putting the burden on the buyer. V'hocha, and in our situation, mocher komasne. It's the seller who is making this statement because he saw that the buyer was upset, so he made the statement. Really, it belongs to the lokeach to take the initiative and say, "I want it in the contract," and he didn't. What did he do? He made a face. He was sad. So the mocher could have said to him, "All right, let's put it in the contract." The mocher could have said that, but he didn't. He said, "Don't worry, I'll take care of you." Therefore, Omar Pitume Mila Ba'almahu. That's why a Maimer takes the position that because the parties did not actually contract, and it should have been on the buyer, or it could have been on the seller, but since the seller didn't put it in either, but said, I'll take care of you. So our Maimer makes this klal, he makes this rule that that's not considered a part of the contract, and he didn't mean it to be part of the contract. So it's merely words. Now, if he's an honorable man, he'll stick by it, but you can't force him to stick by it because that's the whole point of a contract. The contract should be self-sustaining, that whatever you put in the contract, that's what it should be. It shouldn't be, oh, I meant this, I meant that, all kinds of other inclusions, because then ein l'davar sof. There'll never be an end to what people will say. Oh, that's implied. Of course, you promised me that if someone comes to take it away from me, you'll have it. That goes without saying. So a Maimer says, what is it? What's the expression? Buyer beware. You're the buyer. Make sure that your contact, you hire a lawyer, you do whatever you have to do, but you make sure you protect yourself, because once you write a contract, everything is in the contract. There should be no extraneous words, because a contract we can bring before a court and they can see what it says in the contract. You're going to say, oh, he said this, he said that. That's already, outside of the scope. All right. So Rav Ashi is kind of explaining a Maimer. But wait a minute. Now, having said this and having explained what a Maimer really means, he comes and asks a kasha. Ella must listen, Dikatani. We have another Mishnah or Brisa, as follows: that different circumstance, not having to do with achrayas, but here's the circumstance: the seller sells whatever it is, an item to the buyer, and the buyer says to the seller, I'm going to offer you a deal that if you come up with money, because obviously you sold it, you needed the money, but if you come up with money, I will return it to you. In other words, I'll take back my money. No ribbis, no nothing. But I'll be a good guy and I'll let you have it back because I know that you don't want to sell this, but you don't have money, so you have to sell it. So the buyer volunteered to the seller that he would return it to him. Says that brisa mutter. What's pshat mutter? It's not ribbis. Now let's understand what happened here. I sell you my field, and you give me 1,000 zuz or whatever it is. Now that field has produce. So I'm the buyer. I'm going to eat the produce, right?
Yeah.
But if I made a commitment to you that I'm going to return it to you if you have the money, and I've eaten that food during the period of time until it's redeemed, that's ribbis. We've said that all along. That's ribbis, because I got a benefit from the process. Says the Gemara, in that particular case, it's mutter, there's no ribbis.
No
Why
ribbis.
is there no ribbis? Because it's a hard and fast sale. It's not a conditional sale. He said in so many words, I'll be happy to return it to you if you give me the money. So l'chayra, it looks like there is a little bit of an opening here to say, wait a minute, maybe it's not really a sale because he said he'll send it back to him. Says the brisa, unconditionally mutter, because what you said is not a hard and fast statement. If it was a hard and fast statement, yes, it would be ribbis. But it's not a hard and fast statement, therefore it's not ribbis. Why? Demochehu deboilasnuye. Again, we're flipping with a script, and we're saying in this particular case, it's the mocher, the seller, who should have said to the buyer, "Oh, by the way, let's put in a clause that if I have the money to redeem the field, then you'll agree, right? But Mochelo Asne, the seller did not stipulate. Lokeach ko Asne. It's the it's the buyer who made the offer, not the seller. If the buyer made the offer, then so Rashi says. So according to Amemar, um, that it's not really a promise. It's merely a statement. So then, in that particular case, it's not ribbis. Frek the Gemara of Amrina Mashno Resha Mashno Seifa. Now, we have to look back. Last week, we had a brisa, and the brisa had two parts, a Resha and a Seifa. Now, so the Gemara there asked, what's the difference between the Resha and the Seifa? In the Resha, the seller is the one who stipulated that that he would retract and give him back the and take it back or whatever the case would be. So in the Resha, if the moicher made the statement, then we say it's not permitted. But in the Seifa, we say that if the buyer is the one who made the statement, then it's permitted. So here we're flip-flopping. We're saying that the mocher did not make the statement. The buyer made the statement and of his own initiative, and according to a Maimer, that's okay. So how does that comport with the brisa? Because in the case of the brisa, we said that if the seller is the one who made the statement, then it's prohibited because it's considered to be what? Ribbis. Because in other words, he didn't close the door. The point is that it's only ribbis if the transaction isn't complete. If you have a complete transaction and later on there's retraction, that retraction is considered to be a new sale. That we've already established. In other words, you made a sale is over, and later on you buy it back. But in the case where the seller says it, he's leaving open the door that it isn't a final sale. Says the Resha of that brisa, that's why it's ribbis, because he never closed the deal. However, when the lokeach was the one who said it, then we say the deal is closed because I'm buying it. It's over. I'm eating the fruit. If at a later time you come and you say that you want you want a thing, I'll consider it. I'll consider it. So so that's the way we interpret it. V'omar Rava, and Rava there in that brisa, that's the way we ended last week. What did Rava say in that brisa? Sefer Omale Midata, so that you know what? The reason why when the buyer is the one who says it, it's because it was not a hard and fast commitment. It was merely a suggestion. Yeah, I'll take care of you. Right? So that's how that brisa ended. So now he's going to ask the kasha, right? Tamad omale midate. So what's the reason in that brisa that it's not considered hard and fast? It's just a suggestion, right? That that in other words, you can depend. Oh, I'll take care of you. So in other words, if there we want to interpret that because the buyer said it in so many words, right? Yeah, I'll see how it is that that's not binding because he said it. Holo omele midate. that if he hadn't said it in so many words, in other words, it was more of a suggestion than an outright statement, then it would be a proper star. And lo omrin betuva militza be'almahu. And we don't use our Maimer's statement that it's merely just for his benefit, for his to assuage his concern. So what's the kasha? A Maimer says that if you make a promise, and in other words,
It's a comfort promise.
it's a comfort promise, correct? According to this interpretation of the Brisa with the Reisha and the Seifa, it's not just, in other words, we're now making a chiluk between whether he articulated in so many words, I promise to retract and whatever, as opposed to, yeah, you know what, I'll take care of it, I'll think about it. So he didn't articulate the promise specifically, says the Gemara here, that there is a chiluk. But Rav Ashi says, according to you, a Maimer, why is there a chiluk? When you merely say that, oh, I'll take care of you, and there's no specific promise, so a Maimer says that's just merely words. So, so the kasha on a Maimer is, how can you say that? We're deriving a chiluk
From
that
what you said.
if you said it right, you spoke it out, and you said in so many words, I'm going to, I promise, or whatever word he used, to take care of it if it happens, then that's a binding promise. That is a binding promise. But we don't extrapolate that if he didn't say it in so many words that in other words, a Maimer's theory has a caveat. It's not all wide open that a Maimer says whenever you say it, no matter how you say it, what you say it, it's just comfort. It's just giving him, assuaging him his concern. We see, says from Rashi's Kasha, that there is a chiluk between whether he articulated it in so many words or he made it merely a suggestion. So the Kasha on a Maimer is, how a Maimer do you come and say that I guess in all circumstances, when it's not in the shtar, it's just a discussion between the buyer and seller, that it's merely just devarim, it's just words, and therefore you can't hold them to it. We see that in order to understand the Reish and the Seif of that brisa, we have to make a chiluk between whether he said it specifically or he merely suggested it. And if he merely suggested it, then we say it's not binding. But if he said it in so many words, it's a binding contract, even though it's not in the shtar, it's binding. So that's the kasha he has on a maimer. How can you, a maimer, say that it's kind of, generic every time, he says, no matter what words or how he's, gives it over, that it's not binding. So that's
a very, very thin line between.
It's a very thin line, correct.
Rabbi, I have two questions,
Yeah.
one for the first case and one for the second case.
Yeah.
So if in the contract he says, it says in the contract, I'm selling you a certified gemstone that is VS grade G gemstone, and in exchange you're going to give me X dollars. But he doesn't put the warranty clause in that.
Right.
If the gemstone is not certified, then does he not have a right to get that back, because he's not selling him what he contracted for? So he doesn't need the warranty in that if it's implicit in the agreement. So he can't, that's evident. So he doesn't have to make that warranty. It's already in the contract itself, right?
So you're saying an implied warranty?
Well, no, it's an express warranty. I'm selling you a certified gemstone VS grade G diamond. Let's call it a diamond. If it's not, then the buyer can say the sale's off. I'm not paying you. So that is not a warranty. He's saying this is exactly what I'm selling you, and the buyer determines that that's not what you sold me. He has a
Okay,
right to return.
right, but Michael, in your case, that's what we call a mekachtos. It's
Fraudulent.
what's that?
Fraudulent.
I call it fraudulent. It's a mekachtos. We don't want to go so far as say fraudulent. It's a sale, a mistaken sale, a
Well,
mistake.
but let's say it was that grade, but it wasn't certified.
Okay, but if the condition was that I'm selling you a
That's
certified
what I'm saying. If it's
gemstone,
in the contract, then the warranty is already stated. He does not have to say again that if it's not, I'll make good on it because I'll take care of you
right.
because it's already implicit in the contract. So he
Right.
doesn't need to make that additional statement, correct?
Right, correct. But
And,
but but Michael, you're jumping into a different type of contract than what we're talking about here. In other words, you're getting into the finer points of whether or not it had all the criterion of being of what the parties agreed. We're simply talking about a case of a seller sells a field to a buyer. There's no nuances. There's nothing complicated about it. He sells it to the buyer, and the buyer says, "Why do you not? I don't have a warranty. I feel bad. Why don't I have a warranty?" So yes, you should go ahead and get a warranty. If you say, the seller says, "Don't worry about it. I will take care of you if something happens."
but that's
Then
so broad, you can't pinpoint what that means.
so the
So it's
Gemara so
nebulous. It's not a contract. That's
so the Gemara now wants to say we can divide that statement into two, and we can say that if he promised him, um, in other words, if he promised him, um, okay, so based on what Rava is saying, the reason why, if he promised him, it's not considered, it's not a binding agreement because he said, it depends on how I feel at the time. In other words, that was that caveat where he said, depending on how it is at the time, I will take care of you. But that if he didn't say that in so many words, then if he promised him, then there would be a binding contract. According to a Maimer, even that should not be binding because he he alluded to the fact that it would be under his discretion.
but what does "I'll take care of you" mean?
That
It's
that I
very
will,
nebulous. There's nothing
yeah,
specific.
that if a creditor comes and takes the property away from you, what it implies is that I will make good
But doesn't he have that requirement anyway? Isn't that the halacha that if
no.
if he sells you something and doesn't disclose that there's a lien on it, that's misleading, and he has to make good on
So,
that
so, so, so,
sale of
so
land?
Right. So then the question is, why does the Gemara even have this discussion about achrayus? Why are we even worried about a warranty if between the parties? In other words, yeah, if I'm a good guy, I'll take care of you because in other words, I didn't expect the creditor to come and come after me. So the fact that he came after me and I said, I don't have the property, I sold it. Now he goes to the buyer and he takes it. So the right thing to do is for the mocher to say to the lokeach, you know what? I didn't expect this to happen, but I will make do.
But
Halachically, he doesn't have to.
I don't think that if I sell you something and it has a lien on it, and I don't disclose the lien, and another creditor comes and takes that away under the law of land, doesn't he have to replace that land?
Only if the parties agreed that that would be the case.
But
That's
he doesn't know. He thinks there's no lien on the title. And they
which
didn't have a title office then.
which is why, Michael, we said that the buyer is the one who should not
Check
just make a
out.
face, he should say, "Where is my warranty?" We put the achrayus on the buyer that the buyer should say, I'm making a deal, give me a warranty. And that's in fact, look, is it the right thing to do? Of course, it's the
What do
right
you,
thing to do. But al pi halacha, if there isn't a warranty, then the parties were willing to just take a
yes, but
chance.
I don't have the right to sell that to you if there is a potential claim. And
But
I have to disclose that to you, because if I'm representing that it's free and clear, then it's not.
no, I never said it was free and clear. I may have, first of all, I may have creditors that I know that I don't know, and I don't know that they're going to come after this property. Maybe they'll go after something else I own. But no, they want just this property. So I'm stuck. I've got to give it according
So
to
you're saying the
the
buyer doesn't have recourse to say, give me another piece of
no,
property,
he can appeal to him. He can say, listen, I paid good money for this. Why don't you go somewhere
but
else?
he's not obligated, the seller is not obligated in that
No,
case to replace the property.
no. No, and that's right. You think that that's a kind of a bizarre, but this is why the Gemara is telling us that there is such a thing as achrayus, that the parties need to be aware, which is why they should have counsel, of course, but that the buyers should be aware that when they're making a transaction, they need protection. And if he gave up the right to protection, then he's taking a chance. Now, the seller says to him, "Don't worry, and I'll take care of it." But that's where a Maimer comes in and says, no, that's not the same as an achrayus, as an actual written warranty. You have to give him a warranty. You didn't give him a warranty. You're just assuaging his concern that if something happens, that he'll take care of him. It's exactly how the Gemara is presenting it. That's not good enough. Then the question becomes, for our purposes, is there ribis? Because right, because when you're leaving something open-ended, and then you take advantage of, if it's a field, you eat the produce or whatever you do with it, then the problem is, and this is why I say ribis comes at you, and so this is a shogeg by all means, that if it comes at you and you say, wait a minute, this is not a hard and fast deal. You promised me that you would take care of me. So this is where it becomes a little bit. It becomes a little bit.
I am mystified by the fact that, let's say it is this guy secured the property that he's selling, the seller, he secured the property for a loan. It is totally secured, and he represents that he can sell that property to a third person who is a buyer, and he sells it, and the creditor to the loan claims the property for security. He doesn't have to replace that. He can do that when it's totally secured, unless the buyer insists that it's in the contract. I mean,
So
that's
so
why we have title searches now.
that's exactly right. But then their system maybe not have been so detailed. So you're asking Michael that if the seller had made a deal with his lender, is that what
Right.
you're asking? He made
Yes.
a deal with
And it was
his lender.
totally secured for a loan that he had received.
Okay.
So that is totally secured, and then he sells the property, which is still his, but totally secured. And the buyer buys it not knowing that, and has no way of knowing that, because at those times there was no way of understanding whether
Right.
there was.
This is why the Gemara is telling us that under their system at that time, they had an achrayus. They had something called a warranty, which the buyer should have asked for. Well, he should have asked for it. And the fact that he didn't ask for it, at least, is the prima facie suggestion that well, I won't say he wasn't concerned, but he didn't think about it.
Why isn't that ribis? Because he is taking money under false pretenses. They could, if the creditor takes the land, he has money with no and
Recourse.
exchange nothing. So why isn't that potentially ribis? So why doesn't the Gemara require every
Well,
contract to have
why
that
would it
one
be why
piece?
would it be ribis? Because if he takes it
He
back,
sold something that he didn't have the right to, and he took
No,
money
no.
from it. He
Hold
doesn't
on.
have to.
No, no. What do you mean he didn't have the right to? He had the right to transact with that property. It's just he gave a security interest to the lender. But maybe he can sell that property and then replace the security interest with something else. There's no hard.
But but the thing is that the buyer doesn't know any of this.
No, the buyer
But
knows it. Which
he's not renting the property. He
No,
bought it.
he's selling it,
he
but he's
bought it.
selling something he doesn't have the pure rights to sell.
And the
So
Gemara,
the
yeah,
buyer pays him the money and
right.
he loses the property. The seller doesn't have a responsibility to replace that. He's gotten that money under false pretenses and is keeping it. That should be ribis.
Well,
It's not Geneva.
no. Okay. So what the Gemara is being machadish to us here that we're putting the entire onus on the buyer. The buyer, what's when we say buyer beware, that when you come into a transaction and we're giving you the right to include a clause of achrayus, a warranty, and you don't take advantage of it, then
Well,
you're the
why
loser.
doesn't the
And it
Gemara
may not be equitable,
mandate that
Michael.
there is a warranty provision in that agreement because it should not want the potential of what could happen to happen because then there is money exchanging hands for nothing.
Okay,
And that
but right, but a warranty. And look, we know it today in our society, but even at the time of the Gemara, um, look, no one expects something to sort of pop out and make one, and make him the loser here. But in order to protect himself, says the Gemara, that's why we have something called an achrayus. If you waive your right to an achrayus, then
so that's an ill-gotten gain on behalf of the seller in this case, in the case we're discussing, and he's allowed to have that ill-gotten gain. It's not gazlanus because he misrepresented. He does not have an obligation to
no,
replace it. It seems so against what the Torah values are.
yeah, well, and, yeah, I mean, you're sounding right, but now the Gemara is breaking into the finer points and saying that when two people transact, they should contract according to what is halachically permissible, which is I sell it to you, I give you a warranty, I give you a warranty that this property I can sell and no one is going to take it from me, or take it from you if I sell it to you. That's part of that's part and parcel of the transaction between the buyer and seller. In other words, just like there has to be a Kenyan, and where you can make a Kenyan, even by a field. Without a Kenyan, there's no deal. But wait a minute, they agreed, everything is done, it's contractual. Says the Gemara, no, that as the last point in a deal, there has to be a Kenyan. If it's a metaltalin, you have to pick it up, or whatever the case may be. So you're going to say, wait a minute, just because there wasn't a Kenyan, there's no deal. The parties agreed to it. The teretz is that the Gemara is telling us there are steps to be taken to make a deal fair on its face on all sides. And if one party waives the principle of what he is allowed to do, then we say
And the seller is not obligated to return that money if the property is confiscated.
not obligated. He can do the right thing. He's your Shemayim. He'll do the right
But
thing.
that is an ill-gotten gain. That is what we're trying to avoid.
Right. But I hear you, Michael, 100%. And you would say L'chaira, he has to do that.
I
But
mean, that should be an answer to Shemayim at the very least.
no, he will answer. He will answer, of course. But we're talking here, B'dei Adam, does the buyer have a right to go
But he
after the
doesn't have a
seller?
right to sell that property if it's encumbered.
Now,
And
well, hold on. If the agreement between the seller and his lender said you cannot sell this property, it didn't say that. It said if you cannot sell this property, that he's violating the terms of his own agreement, and the outcome would be different. But if he has multiple properties, he takes this one and sells it. Just so happens the lender comes back and says, "No, I want that one." Now, maybe the seller can replace the property to the buyer with a different property. Again, we're not going into all of that. That's certainly
But the
possible.
buyer doesn't wants that property.
He wants this one. He wants this one because
So he
it's
should have, if that is encumbered, then he should have the right to at least recover the proceeds from the sale.
I'm getting a little lost here. Excuse me,
what?
Michael.
Yeah.
Uh, make start the story simply, please.
Okay,
Okay.
it's simple. There's a seller uh, who has a property, but he used that property to secure a loan, dollar for dollar, in another transaction. And so the lender to that property has a 100% security interest in that property.
But the property, one second, he can't be selling that property.
Well, that's what I'm saying.
No, no,
But
no, no. In the agreement between the seller and the lender, there is not a clause
right,
that you can't sell that property. It's only a security against the
right.
loan that you made, but it doesn't say you can't sell the property to
Okay,
him.
but as a security, there have to be more words in case he sells it. And the earlier, when you have a
Yeah,
loan
the
as
Gemara,
a
the Gemara,
security,
yeah, but we're not too worried about the
no, but there
language.
has to be something there that's specified that if he sells it, then I have to replace my security with something else.
And that may or may not be the case, but we don't want to get into the
But that's a
relationship.
different transaction.
Different
A totally
transaction.
different
Totally
transaction.
different. Exactly.
But
We don't
this
want to get
guy
into that.
sells the property. The property, the guy pays good money for the
And
property.
it's his.
It's not. The creditor can come and take that property. And what, if I understand correctly, I'm still mystified, is that it's tough luck on the buyer because he should have put a clause in to his contract that this guy had that
So
there
what
was
is the
an
Yeah,
encumbrance
Michael.
on this
So,
property, and
so
you
there was a
weren't to make
lien.
sure.
So, Michael, there was a lien on the property you just talked about.
Yes, but as Rabbi said, in the agreement on the lien, there was not a statement that he cannot sell the property. He still owns the property, but it has a security interest in it.
That's right.
And what they're saying, what the Gemara is saying, as I understand it, is that if he has the right to sell that property to a third party buyer, even though it's totally secured. And if the lender who lent the seller the money comes and takes that property, the buyer's out of luck.
So Michael, stop a minute. What is the Gemara really trying to tell us here? It's trying to tell us that when there are halachas that apply, or principle, I won't say halachas, when there are principles that apply between a buyer and a seller, those principles have to be honored. It's not to say that it was inequitable. It was inequitable, but the Gemara is saying that in order for commerce to be actually be actualized, so that there should be buyers and sellers and lenders and borrowers, you have to follow the law. You have to follow the rules, and the rules are that when I sell you a property, you should have a warranty. I overlooked it. You cannot overlook it. And now, the problem is that, and we're going to see probably next week, it depends on when that warranty should have been given, in the beginning of the transaction or at the end of the transaction. But let's not get into that. The fact that there was not a warranty, and a warranty is part of the way people do business, says the Gemara, you have forfeited your right to have a a claim on the seller. You forfeited your right. Now, it seems very, very inequitable, and you're right, Bidei Shamayim, there's going to be a lot to answer for. But when it comes to a transaction here down on the earth where we're dealing between a buyer and a seller, everybody's got to do their thing. Now, let's stop a minute. Let's bring it to today in our courts. Forget about the Bezin for a minute. I'm going to tell you, okay, that I mean, I've had this as an attorney, but when two people contract, there are rules. If you violate the rules, you're at the mercy of the other party. There are rules here. Now, we sometimes have something called an implied warranty, an express warranty. Let's put that aside. Let's say that there has to be that it's not an implied warranty, it's an express warranty, and you omit it. Then the court's going to say you were willing to take a chance, and now you're going to lose money because you didn't dot the I's and cross the T's. That's exactly what will happen.
You didn't protect yourself.
You didn't protect yourself. Says the Gemara, we have something called an achrayus, and that should be in the deal. Now, the seller should have put it in, but the seller omitted it intentionally, unintentionally. But that's why the buyer should have at least someone looking over his shoulder. And if he didn't, then it's hard to express this, but shame on you that you didn't follow the rules that between a buyer and a seller in every case. Now, so now we're introducing a maimer, and our maimer says, you know what? We already signed the deal. It's going forward, but I'll take care of you if something happens. So now, outside the shtar, outside the four corners of the contract, he's making a statement. And that statement is, I'll take care of you. Says the Gemara, that statement has no real value. It's merely what we call puffing. You're just making a statement, I'll throw it out at you. Okay. So that's a maimer. Rav Ashi is asking him, how can you say that a maimer? Because now Rav Ashi is the one who's splitting the hairs, and he's saying that if, um, okay, it's not binding when he says in so many words, depending on what it is at the time. In other words, he didn't say, I'll absolutely reimburse you. He said, we'll see what it is at the time. So he spoke that out. So in the case where he spoke that out, then we say that it's not binding. But holo amalei medate. So there's an inference here. Are we deducing from this that if he did not say in so many words that it's depending on how he feels at the time, then the promise would be binding. It would be an actual promise. Says Rav Ashi, but according to your Maimer, it shouldn't be binding even then. It should. Why do you say it's binding just because he didn't express it in so many words? He's already indicating to him that he would be a good guy and take care of him. And that's merely puffing. That's merely just throwing out some words. It should not be part of the deal. Yet we see, according to Rav Ashi, it is part of the deal. So his kasha on a maimer is, a maimer, you're making a blanket statement. And you're saying that in every situation where we have a deal, but at the end of the deal, I say, don't worry, if something happens, I'll take care of you. It's okay. We see that there is a difference between midate and lo midate. If he said it in so many words, or he didn't say it. So the chayra, that's Rav Ashi is asking on a maimer, how can you make this blanket statement? It seems as if we can divide circumstances to when he expressed it in so many words, or he didn't. And if he didn't express it in the way it should be in so many words, then it should be a binding agreement. Why am I you saying it's just puffing? It's a binding agreement. That's the kasha. Now, I understand, Michael, your concern. And again, from the standpoint of did he do right or wrong? Okay, he didn't do right.
But Rabbi, at the very least, he should either have to return the money he received in exchange for the property, or give him an alternate property to make. Otherwise, he's gotten something ill-gotten.
Right. Now, he doesn't have more property and he spent the money. What should he do?
Give him an IOU.
An IOU. Okay. Okay. Again, all those things should be available to him. And I think for our purposes, though, the Gemara is only trying to show us Now, I'm not saying that all those things aren't the right thing to do, but the Gemara is trying to say that from a black and white halachic decision, if you come to the Bezdin and say this star did not have an achrayus, therefore I shouldn't be held responsible, the court would say you're right. Now, do the right thing, do the
Well,
right thing,
it's incongruous, Rabbi, because in the original, when we were talking of, price gouging,
right,
if somebody charged more than 5%, they had to
right.
make up the difference.
Oh no, right.
In this case, he got something for nothing and he doesn't have to return.
Except that again, you're looking at it from really the perspective of what's right and what's wrong, and I understand that. And
But
that
in the case of no, what
what
no,
you call price
no.
gouging, there does not have to
But the,
be.
but but the thing is, the Torah comes on and says you can't do it. In this case, the Torah doesn't say you can't.
That's
The
right.
Torah is trying to protect the buyer and the seller in that case. In this case, it's not. It doesn't make sense.
I understand. Believe me, I understand. There should be a mechanism by which the buyer can reclaim something from the seller if this particular
Right.
situation
I
arises.
mean,
But
Michael
then,
has a good caution here.
no. But then, what's the point of the Gemara introducing
The
the
whole story.
principle of achrayus? Why should that even be on the table? If what you're saying is right, and I'm not saying, Michael, it's not, what's the point of an achrayus? Forget about it. We don't need
Well,
an.
there are certain circumstances where an achrayus, because you say something can do something. You're buying a product, or you can say this. You're buying a horse, and you can, or an ox, and you say this can pull, 3,000 pounds, and if and it can only pull 1,500 pounds. So you know that's there are cases. This is a case of outright misrepresentation, that you have something unencumbered that you're selling, and then okay, so it was encumbered, it was taken away, and then you're allowed to walk away scot free with the guy's money when that's a possibility you didn't disclose. Now, you're right, Rabbi. I mean, as a buyer, he had the recourse, but in those times, you said things were a lot simpler. So he doesn't have the ability to look and, check titles and
But he
everything.
doesn't have to. He doesn't have to check anything if in his document there is a warranty that says if something happens, I will make good. So we're
What
not
well, what
asking
does
him.
that mean? That's too generic.
No.
No,
The
no.
warranty
If
says
if
the
there's a
war.
credit, if there's a lien on that property,
That's correct.
then he
No,
would
if
do
it
something.
said that,
Yeah,
but it
but
should
Michael,
then.
that's not ambiguous. That's not ambiguous if you
No,
say.
if it
Very
says
clear.
that, that's fine. But there are other possibilities.
But in your example of the horse, if I commit to you that it can pull 3,000 pounds, it can only produce pull 1,500, then of course I misled you, and of course you should have recourse. But that's why the whole purpose of achrayus is introduced, is that it should be a level playing field. The seller sells on the property. The buyer has no idea what the history of that property is because there is no title search. Okay. So we do a title search and we still ensure that the title search is accurate. I mean, we go a long way here in our
Yeah.
system, right? Because we've learned lessons. We've learned lessons when title searches were faulty, missing information. So we say, on top of that, we're going to ensure. It was a simpler time, and the Gemara simply says that the seller can sell, the buyer can buy, and the buyer protects himself with an achrayus that if the seller misrepresented or couldn't sell, or someone is able to reach into the possession of the buyer to take something the seller owes him, that he has recourse. So, Michael, you're not wrong, of course, but this is a moral issue as opposed to a
Well, but
legal
from
issue.
a moral standpoint, the Gemara should ensure that a
Yeah, from the moral
warranty clause
standpoint,
is
he totally
included
did
in
wrong.
every contract.
But so the Gemara is telling us that morality does not enter into a business deal. It could be totally immoral, but there is and we're giving the buyer a way to protect himself. Simply put in the achrayas. Once you put that in, you don't have to worry about the guy's morals because at that point in time, he is, he's
To me,
agreed.
it's
Now,
just that so upside down, like I said with Ona, that that it's stepping in before, and you can't have a market price is set. You can negotiate if the guy wants to pay more, he can't pay more because
but there you're talking about people without knowledge. So without knowledge, we're saying we're
Well, we're
protecting
talking
you.
here. You're saying it's simple times. People without knowledge bought land, and they bought it on the good faith that I can
Okay.
sell this land, and it's
So
unencumbered.
yeah.
It's
So I'll
just
answer you, and I'll
inconsistent.
tell you that in the case of Onar, inherent in the principle of Onar is this principle of being able to go back and collect if we made an error more than 15%, 12, whatever it happens to be. But that's inherent in the deal. The Gemara never said, oh, by a no, you got to have a written contract that this is the right price. Otherwise, you can't come back and claim. That was the principle of the Gemara, saying you don't need to do that. Here, the Gemara is introducing a principle between a buyer and seller and saying specifically, protect yourself. Don't just allow it to chance that the seller's a good guy. We're giving you an opportunity. Now, you pass on that opportunity, but the seller says, don't worry, I'll take care of you. That's not good enough. Now, according to Maimer, it's not good enough. The kasha here is there should be a difference as to whether he articulated it in so many words or he inferred it. And the Gemara wants to say that when there was an inference and not an articulation, that it is a binding statement, and therefore he should be able to collect. It's not quite a chrayas, it's not quite a warranty, but he can hop on it and say, "But you said such and such, and I'm taking you up on that." That's how Rav Ashi wants to sort of split a maimer and say, a maimer, your statement is not generic. It depends on the circumstance. Michael, there's no question that everything you said is correct, except that why would, and I'll say it again, why would the Gemara even introduce the principle of achrayus if it's understood that any time such a circumstance happens, of course you got to get your money back. It says without question you got to get your money back. Says the Gemara, no. We're not going to allow it because we are introducing the principle of achrayus. You've got to follow the letter of the law. Put the achrayus, it's a simple thing. Put the achrayus into the contract, and you have a contract that protects everybody.
And it's
Failure
still
to do
simple.
so, buyer beware. And
Even
that's
with
how,
the achrayas, it's still a simple situation.
even without the achrayus?
No, with this,
Oh,
with
with the achrayus,
achrayas,
of course it's a
it's
simple
a simple
situation.
situation.
Very simple.
Have a
Very
good
simple.
day. Kind of
Very
thing.
simple. And the fact that the Gemara is telling you we give you the opportunity to protect yourself, and you don't want to protect yourself,
It's on
okay,
you.
shame on you. Michael, it's still not morally right, but morality doesn't enter into the picture here when we're talking about a business dealing where the halacha is you have a right, seller, you have a right, buyer. If exercise your right. Okay, so I mean, there's no other way to couch it. He
Well, I
I hear you,
hear
Michael. You're not wrong. You're
I hear
absolutely.
it's just that the Gemara goes to such great lengths to
Yes,
protect both sides. In
yes.
every other situation, and in this one, it says you're on your own. It could have mandated that in writing, if there's a contract, there has to be achrayas in there, that there has to be a warranty
You're right.
specified in there, and
You're
that would protect both
you're
sides in the
right.
case that
You're
happened.
right.
But they're not requiring that.
That's
It's up
not
to
required.
you.
No, no,
So
you're correct that if there was a mandated and you didn't have it, then the contract is null and void, of course. But
Nowadays, when people are buying fields and doing just the same thing. I suspect there's a warranty written, or at
Oh,
least it's being waived.
you better believe that there is every which way to Sunday. You're looking for protections and for to make sure that everything is solid. Obviously, in the time of the Gemara, obviously there was loopholes, and they didn't have a title search, and they didn't have all this other things. They relied on each other. So the Gemara is saying, you buyer, you want to just because he's a nice guy on the outside. Protect yourself. Once you put it in a achrayus, as nice as he is, if something pops up, now let's give him the benefit of the doubt. Let's say, oh, he didn't remember, the seller didn't remember that he had this loan from 20 years ago, and in that loan, the lender had rights to his property. He didn't know it, forgot it. 20 years went by. Now he sells the property. And out of the blue, this lender is coming and saying, pay up, Reuven, pay up. He says, I don't have what to pay up. Go to Shimon. I just sold him my only property, and that's what you need to cover your loan. Go get it. I don't have money to give you. So, in other words, of course it's wrong. It's wrong to do it, but the Chazal is telling us, the Gemara is telling us that we're going to give you the right to protect yourself. Take advantage of that right. It's your right. So if you don't do it, then you're okay. I mean, uh, how do you describe someone like
You
that?
didn't do enough.
He's a simpleton. I mean, whatever, he didn't do enough. But again, if the Gemara hadn't put into the situation where an achrayus is necessary, Michael, you'd be 100% correct. But by introducing an achrayus, the Gemara is saying to us, buyer, you must follow the rules. And the rules say that when you're buying a piece of property, you ask for an achrayus. I mean, again, we can go round and around, and you're not wrong, Michael. But the fact that the Gemara tells us that that's how you interpret when the Torah says a buyer and a seller. Again, the Torah doesn't go into this detail of achrayus and all of that. The Gemara is expounding on what the words of the Torah is that when a person sells a property, okay, fine, it's sold. Now, what are the weeds? The weeds are that what happens if the seller has a loan coming due, and what happens with the buyer? How does he take advantage? How do you take care of the buyer? Says the Gemara very simply, just add the achrayus and you're protected. So yes, there is an incongruity here. I'm not going to tell you there isn't, but again, the Gemara has to sort of lay down the law and say that without an achrayus, you are putting yourself on a limb. But let me just finish the last line here because the Rav Ashi asks this question on our Maimer, and it seems to split the circumstance. And according to our Maimer, there is no split. Anytime there is just this, sort of words of comfort, if you will, it's okay. So Rav Ashi wants to, Maimer comes back and says the following: Nase kamanda omale midate itmar. And so again, the Gemara's answer is kind of like a band-aid on the question. The question is that is there not a difference between speaking it out in so many words and implying it? Says the Gemara, Nase kamanda omale midate, that when Rava was saying and quoting Abaya, that everything, even if it's inherent, it's as if he said it. In other words, we're saying that if he said it, it's okay. Don't have to. It's not binding. There's no ribbis. But if you, I'm saying if you said it, then there's no. Yeah, it's not ribbis because the deal is a deal. But if you didn't say it and you inferred it, then it's not really a deal, and therefore, when you eat the fruit, it's ribbis. Says Maimer, no, even if you didn't say it, it's as if he said it. I mean, this is the Gemara sometimes wanting to sort of put the Band-Aid over the wound and saying that what Maimer really meant to say was you don't have to say it in so many words. It can be inferred, and it's as if he said it. And once he says it, then we say it's just merely words. It's and therefore the deal is finalized. You can eat the fruit, and if you sell it back to him, there's no ribbis. Remember, this whole thing discussion is about ribbis. We're you know we're putting the cart before the horse because we're getting into detailed discussion about the equities of a buyer and a seller and what the obligation is on each of them. And that's a critical discussion. But the bottom line is we're more worried about ribbis than we are about the parties. So if we say that the deal is consummated, then there can't be ribbis because later on, if he sells it back to him, it's a new transaction. But if you're going to say that his words, in other words, the seller's words have a power in the deal, then the deal was never consummated. If the deal wasn't consummated and the buyer ate the fruit, that's ribbis. So that's how we come out. So our main Rav sort of protects himself and says, no, there's no difference between midate, shalom midate. It always comes out that he said it in so many words, even if he didn't. All right, it's not the strongest answer, but that's how our main Rav is interpreting it. But all right, so we'll stop here. But again, I don't want to leave you with the impression that there is something not right with this deal. Certainly, there is a morality issue, but the Gemara is not getting into the morality. Yes, you should do the right thing. Maybe b'dei shemayim, they're gonna punish you, but here we are, and we're stating principles of commerce, buyer and seller, and therefore everyone needs to take advantage of what is offered them. And if the buyer is offered the possibility of achrayus, he needs to do it. He absolutely needs to do it. And if he doesn't do it, says the Gemara, you can't now force the seller to be beholden to him if that lender comes out of the woodwork and says, you owe me the money, and he says, I don't have it. I just sold my property. Then it's unfortunately tough luck on the buyer. Everything you said is correct, Michael. I don't want you to walk away thinking that you're not right. But we have to understand how the Gemara establishes the principles of commerce is that they're giving everybody a fair opportunity to protect themselves. And if you don't take advantage of that, we're not going to overstep our boundaries and say, we're going to protect you because you didn't protect yourself. The case of Ono is different, by the way, because in the case of Ono, we're dealing with something quite random. And from both sides, the seller may not know what the right price is, and the buyer may not know because they haven't consulted. I'm in a business of selling, and I'm selling you a product. Turns out that I'm selling you a product for way more than I should have, says the Gemara. Fine. Then we're going to say that that was a mistake on your part, and you're going to have to reimburse. But again, there was nothing contractual there. It was simply, I'm selling it to you, you're buying it from me, and
But
then
it could
the
have been,
principle of
I don't want
law
to belabor
comes into
this.
play.
It could have been contractual. It could have been, I'm selling you this for and for 50 zuz for 1,000 pounds, whatever it is.
Yeah.
And and it's in writing. And even if that's not the right price, you agreed to that. You had the right to put a warranty in there if you said, say if we determine that this price is more than X% of the market, but here the law steps in and invalidates the deal, but not in this other case. So, because it's unfair. So it sticks its nose there where it's two parties. They could protect themselves. There, they don't step in. Here, they do step in. It just doesn't make sense to me.
Yeah. Yeah. Understood your concern. I will say that we'll leave it at that. But the Gemara has the finer points here of not mixing one issue with another. And again, maybe when we think about it in more detail, we'll figure out a way, even with Ono, where there could be a contractual agreement. Usually in Ono, in those circumstances, even if it is in writing, we're saying, again, it's different than where there is an existing lien or an existing loan. We can see the difference. We can see the difference where the seller is where the seller may have other responsibilities on that land. And the Gemara is saying, you know how you protect yourself strictly with an achrayus. But in the case of Onoah, intentionally we're saying that it's a different circumstance. Yes, if he would have had an achrayus, if he would have put in a warranty on what he was buying, then there might be an issue of, well,
Buyer beware. It's the same
no, but
consideration.
yeah. So the Gemara is trying to tell us that oh no supersedes buyer beware. Oh no supersedes it. In this case, it does not supersede. Believe me, there's it's a nuanced distinction, but nevertheless, we'll go by it. But next week, Mitzvah Shem, when we go further, we're gonna break this down even more to understand how the deal was struck and give other comparisons. It's a fascinating ongoing discussion. So, all right.